Hello and welcome to Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson, and I own Covert Ops Jury Investigations. What do we do? I'm glad you asked. We find the jurors who lied during jury selection so that they would be chosen and our clients would be convicted. In this podcast, I'm going to focus on another judge. One of our clients filed a motion last year for a new trial based on the juror misconduct that we discovered when investigating his jury. On Friday, the order from the judge came down the pike, and he denied the motion for a new trial, juror interview, evidentiary hearing. Just said no. Who was that judge? It was Milton Hirsch. Milton Hirsch from Miami-Dade County, Florida. He's been a judge of the 11th Judicial Circuit of Florida since January of 2011. He is also an adjunct professor of law at the University of Miami School of Law. After graduating from Georgetown University Law Center, Judge Hirsch worked in the Miami-Dade County State Attorney's Office, rising to the position of Assistant Chief of Narcotics Prosecution. In January of 1987, he entered private practice. Now, I read that. This is, I believe, from one of his books that he's written, the back cover, the jacket of it. And when I read that, my first question was, why would you go from law school to the prosecutor's office, where you're clearly a star, to private practice? Says he was routinely listed as best lawyers in America, Florida super lawyers, top 250 criminal lawyers in South Florida, and other like-kind publications. And again, he wrote books, has written books. So I started looking into Judge Hirsch for reasons that will become obvious in a few minutes. And I wondered, why did you go from prosecutor to private practice? Made me think of another judge that I've talked about in previous podcasts, who went from the prosecution's office, star, Florida Prosecutor of the Year, to being allowed to resign. And I want to hope and pray that it had something to do with all the crimes that we exposed of hers. Maybe not. And then ran for judge and became a judge. So this got me thinking. I also thought about another judge who was clearly biased. I've mentioned him in prior podcasts. He was our trial judge, Daniel B. Merritt Jr. So I started looking into Judge Hirsch to find out what happened. I found a news article in July of 1985 in the Miami Herald. It's entitled, "Man Sues Reno for 2 Paychecks." Now, I don't know if you're old like me, but I remember, because I'm from Florida, I remember when Janet Reno was the attorney general. This is when she was the Dade State Attorney, Dade County. It says, "Sue Janet Reno for theft?" "Yes," says a former prosecutor. Dade State Attorney Reno has been named a defendant in a lawsuit filed by a lawyer who once worked for her. Milton Hirsch, 32, now in private practice, alleges that Reno committed civil theft because she withheld his last 2 paychecks, totaling about $2,500. He said, "She certainly has no legal right to hold them. My employer was the state of Florida. The state of Florida issued those checks." Reno says she's holding the checks because Hirsch did not complete his disposition reports on the cases he had handled. She said if somebody doesn't do the work, they shouldn't get paid. And then it says Hirsch, who resigned as assistant chief of the narcotics division, resigned, said he finished the job. Reno says it's not enough. Not all of it has been done, and no trial date has been set. Found another article a few years later in 1990 that shows that Judge Hirsch, former defense attorney Hirsch, former prosecutor Hirsch, at one point understood the importance that jurors play in our criminal justice system. I probably shouldn't say play because it's not a joke, but I think to a lot of them it is. It's a game show. This particular article says barroom brag gets juror in police brutality case booted. A juror in the Mercado Cops trial got booted off the case Wednesday after boasting to barroom buddies that he was the main event on the local evening news. I won't say his last name. Mr. Gerald, a boat salesman and charter operator, told fellow patrons at the Travelers Lounge in Miami Springs to tune in so they could all watch him, a defense attorney said. Just the day before, the defense attorney, by the way, was Milton Hirsch. Just the day before, Mr. Gerald had sent a note to the U.S. District Judge in the case, and he asked, how could the government prosecute a civil rights case against 6 Miami cops if the man they allegedly beat to death, drug dealer XYZ, forfeited his rights because of his arrest record? Now, it certainly sounds to me like he was going to vote not guilty. Don't know, though. Then it says defense attorney Milton Hirsch reported this barroom behavior to bravado, was the exact word, to the judge. Hirsch said he received a late-night telephone call from someone who had been at the bar. The caller told Hirsch that this Mr. Gerald even pointed himself out in a courtroom artist's sketch. The judge called Mr. Gerald into the courtroom, thanked him for his time and efforts, and sent him on his way. So, simply boasting about being on a jury, and I get that judges tell you not to watch the news, not to talk about it. I get that. So he violated this judge's order to not participate in any sort of biased behavior during the trial. But even Judge Hirsch, the former defense attorney Hirsch, knew then that that alone was enough to get this juror booted off the jury. I found another article from 2003. This is actually written by Milton Hirsch and another attorney. And again, I'm doing this to show that at one time, Mr. Hirsch believed in our Constitution. And yes, I'm wearing this shirt on purpose. I'm not going to go so far as to wrap myself in the flag, but I kind of am. I'm making a point. We do what we do because we want to uphold the Constitution. Our Bill of Rights gives you rights. You have the right to a fair trial by an impartial jury. And when we show that you didn't get that, then the state owes you a do-over. Yes, Judge Hirsch, the state owes you a do-over. Doesn't matter how long it's been, they owe you a new trial. If you can't retry it, then guess what? Work a deal, time served, go home, start over. In this article, Milton Hirsch said, Magluta was wronged. Miami's last cocaine cowboy rode into the sunset last week. Salvatore Magluta, I think is how his name is pronounced, considered one of Miami's most notorious narcotic dealers, was prosecuted in federal court for having witnesses murdered and laundering millions of dollars in drug proceeds. Now, am I saying he's guilty or innocent? No. I have no idea. I don't know this man. I don't know this case. I'm just making a point by reading what Milton Hirsch believed at that point in time. He said, a federal judge punished Magluta with a 205-year sentence. He's 48 years old. He will live in prison till the day he dies. But Magluta was never convicted of the homicides for which he was sentenced. A jury of his peers found Magluta not guilty of the murders and guilty only of the nonviolent money laundering charges, crimes that carry a maximum sentence of only 20 years. The jury's verdict notwithstanding, the judge decided that Magluta was responsible for the homicides and sentenced him accordingly. Mr. Hirsch said the message is that prosecutors can lose and still win, that a jury no longer stands between an accused American and a life sentence. The jury is a special American institution and has been, until recently, the heart and soul of our criminal justice system. The jury stands between arbitrary rule and the citizenry, and it's a shield against overzealous government. Our founding fathers recognized that even an independent judiciary was not enough to protect us against the abuses of power. They didn't trust judges to mete out justice on questions of guilt or innocence. To determine the answers to these questions, the founders wanted the common sense judgment of citizens. Acting upon the court's 1997 ruling, prosecutors and judges have found ways to end run jury verdicts and the jury system itself. Judges sentenced defendants convicted of lesser charges as though they had committed other, more serious crimes, even in the face of a not guilty verdict by a jury. Based on inconclusive evidence or even rejected evidence, a judge is free to send a man to jail for life. Not guilty doesn't mean anything anymore. Conviction is optional. He further said, it is the jury verdict that separates America's legal system from that of so many other nations. All countries, even the worst, have laws, judges, and lawyers. Most have trials, or what are called trials, and many even have juries. But in too many of those countries, a verdict is a foregone conclusion. The prosecution having indicted, the jury is simply a rubber stamp. In Magluta's case, the jury's verdict was treated as irrelevant, and because it was Magluta, no one cared. As Justice Felix Frank further famously warned, it is easy to make light of inconsistent, of scrupulous regard for the safeguards of civil liberties when invoked on behalf of the unworthy. It is too easy. History bears testimony that by such disregard are the rights of liberty extinguished. Heedlessly at first, then stealthily and brazenly in the end. I hope you keep those words from Judge Hirsch resonating as I begin to tell you the whole point of this podcast. I did look up some of his books. I have not ordered or read them. I'm going to. But I did notice that one of them, this is the cover, The Wheel of Justice. And I found how ironic that he chose Lady Justice with balanced scales and a blindfold to represent his book. Because as you will see, as you will hear, I should say, I think the wheel of justice that Judge Hirsch is referring to is himself. There are no wheels, just wheel. Why do I say that? Well, because as I said on Friday, our attorney's motion was denied, and now our client has to go to the appellate court to try to seek relief, which can take years, more years. He's been in prison for over 20 already. His family is the one who hired me. They insist that he was wrongfully convicted. In fact, I'm going to stop right here. Whenever someone calls me and starts to tell me about their case, whether it's the person that's incarcerated or their family, I listen to their story. They all have, well, not all, let me back up. Most of the phone calls start off with them explaining how they were wrongfully convicted and how now, years after trial, they have proof that was not presented at trial. Had it been, they would hopefully have not been found guilty. The family members insist that their loved ones are innocent and they want them home. There are a few that when I get the feeling that I'm being okey-doked, I say this, and actually I say this on every phone call. I tell them, listen, if the state has you dead to rights, if you are the one, you did exactly what they accused you of, you did exactly what they convicted you of, and you've not been wrongfully convicted. You are not innocent, and you don't have proof that it was someone else or that you were framed. If that fits you, then you are wasting your time hiring us. And we are wasting our time looking for a juror that lied to get on your jury. Because at the end of the day, the state attorney's office, even if it's been 20 or 30 years, is either going to refuse to offer you a deal, or they might actually take you back to trial and retry the case. I don't get return phone calls. You will see on our website, if you go to juryinvestigations.com, we work with people that were wrongfully convicted. Now, do I know that they're innocent? No, it's not my case, but they claim they are. So like us, we want to help them. We want to give them a second chance. Well, Judge Hirsch went to our website. In fact, what I found comical, well, I will say, as my husband and I read through this, we laughed and high-fived a lot. And then in the end, after reading it the second time, I started to get angry because we are all about truth. We are all about looking for liars. I say that. We look for liars. If you get your jury summons and you come into court and you're not honest and they ask you questions and you lie, you're right. We're probably, if we're hired, we're going to find you. Not probably. We will. We will find that you were not truthful. So you know what? My hope and prayer is that through all of these podcasts, the one thing that resonates is when you get a jury summons, don't try to get out of it. Be honored. Go into court. Dress appropriately. Don't show up in flip-flops and tank tops. My God, I am just horrified at what people come into court wearing. Dress like you're going to a wedding. Show up. Be respectful. Tell the truth. If they ask you if you know anyone who's ever been arrested, say yes if you have. If you haven't, then be honest and say no. All right, I digress. I'm going to get back to this. This order on the defendant's motion for post-conviction relief denied by Judge Hirsch. I'm going to just read a few excerpts from Judge Hirsch's denial. He quotes on page 2, in 2006, Mr. Pierre, that's our client, assisted by competent and experienced counsel, was tried for and convicted of some, but not all, of the very serious felonies with which he had been charged. His judgment and sentence were affirmed by the Court of Appeal 2 years later. Since that time, he has filed a motion for post-conviction relief, an amendment to that motion, and a supplement to that motion. His claims were denied, which denial was reversed on appeal, and the matter remanded to the post-conviction court. After a hearing, Mr. Pierre's post-conviction claim was again denied, and this denial was affirmed in 2013. In the ordinary course of things, that should have been the end of the litigation of this case. Okay, I'm going to stop right there and say, yeah, the problem with that, Judge Hirsch, is that Mr. Pierre has a life sentence with no chance of parole. And have you even considered the fact that maybe in 2006, his trial counsel was not competent or experienced? Do you even know who these attorneys were back in 2006? I don't. And what if he's innocent? What if he's innocent? We know that the appellate courts in these post-conviction motions are not challenging the jury verdict. I'm not an attorney, but I know that. They are simply upholding the lower court's decisions. What if he's innocent? Should have been the end of the litigation of this case. So that's it. That's all you get. A few tries, motion denied, motion denied, motion denied, go die. That's where we're at. Then he says, a dozen years later, however, Mr. Pierre's litigation has been reinitiated by the author of the motion at bar, attorney Brian Savy. Mr. Savy apparently has a very close connection to a business calling itself Covert Ops Jury Investigations, LLC. That company's very elaborate website adorned with military imagery evocative of the Rambo movies, announces, among a great many other things, that, quote, "We have completed 105 investigations and uncovered at least one biased juror on every jury. We are 100% successful because we do not stop searching until we find that biased juror." Yes. In fact, we're up to 110 now. Probably didn't want to hear that, did you? Then he says, more particularly, I've never been able to say that word right, to find the biased jurors. And he's quoting from our website. And I will just add, before we get any further, he cherry picked. If you go to our website, you will see the words wrongfully convicted on there. You will see that we look for liars. You will see that the only thing a juror needs to be concerned about when dealing with our company is, did you lie or did you speak the truth? If you spoke the truth, guess what? Great. You did your civic duty. You have our accolades. But if you didn't, you're right. Look out. To find the biased jurors, this is quoting from our website. To find the biased jurors, we search hundreds of public records looking for information that indicates they intentionally concealed their true self during the voir dire to improve their chances of being selected for the jury. Yes, I wrote that. We researched the jurors, their family and friends, and everyone associated with the case, meaning accusers, victims, their friends and family, law enforcement, witnesses, all courtroom personnel, etc. I think that's what struck a nerve. Yes, all courtroom personnel, judge, bailiff, court reporter, attorneys, witnesses, everybody that was there at trial. We look into everyone. We're looking to see, did they have a connection to one of the jurors that was not disclosed during jury selection? Our mission is to find potential juror bias so you can get back in the courtroom and have a second chance to be free again. Yes, that's what we do. And I'm very proud of it. And then he said, and then in large capitalized colored font, want us to find out if any of your jurors were guilty of misconduct? Click here. Yes, I wrote that too. He said the website includes a disclaimer that, quote, Covert Ops Jury Investigations, LLC is not a licensed private investigation company, nor are we licensed private investigators or attorneys, but we work closely with them, end quote. Here's where I started to get angry because I am very proud of our work and I'm honored to be a part of several attorneys that we work very closely with. Are they affiliated with our company? No. They are independently hired. They do their own thing. But it wasn't right of this judge to throw Mr. Savy under the bus. He's an honorable man. He said Mr. Savy's name appears several times in the website as having represented persons who retained Covert Ops Jury Investigations, LLC. Apparently, the motion at bar is the product of the Savy/Covert Ops connection. Histrionic and exaggerated as some of the language on the Covert Ops website may be, Mr. Savy and Covert Ops kept their promise in Mr. Pierre's case. Quote, they search hundreds of online public record search engines. Well, thank you for at least acknowledging that. We did exactly what we promised we would. Then he says, initially, the Savy Covert Ops team attempted to obtain from the court itself the home addresses of the jurors who had served 2 long decades ago on Mr. Pierre's trial. Apparently, that information was unavailable. It had been destroyed by the clerk's office. I interjected that. He didn't say that. I'm just telling you when I asked, it had been destroyed, so we couldn't get addresses. But what was available was the verdict form himself, which bore the signature of foreperson Charles Moore. Covert Ops then searched online records and voter registration records to find a similar signature. They obtained a document associated with a 1993 real property transaction that bore a signature that, in the opinion of Covert Ops, recall the website disclaimer, they are not licensed investigators nor presumably of qualified handwriting analysis. They closely resembled the one on the verdict form, according to Covert Ops. Yes. Proceeding on the naked assumption. Oh, now see that word? That's a bad word. We never assume anything in our company. We laugh about it, and then we look for proof. But Judge Hirsch chose to use the word assumption. He said that we assumed that the Charles Moore whose name appeared on the 1993 real property document was the same Charles Moore who served as foreperson in Mr. Pierre's 2006 trial. Covert Ops then took it upon itself to obtain a marriage license and a real property deed for that Charles Moore and military records for that Charles Moore, and in all manner of information about immediate and extended family members of that Charles Moore. I'm just going to show you something, and you tell me what you think. We did not claim that we are handwriting analysts, but keep in mind, here we are 20-some years later. The clerk of court has destroyed all records of the jurors. They were asked very little information during the voir dire. And all we got were first and last names. And of course, Charles Moore is a very common name. And we're talking about Miami-Dade, Florida. So there are presumably hundreds of Charles Moores. But what we did was we got the verdict form and we looked at the signature on the verdict form, which is something that we always do in our cases where we always ask for the verdict form so that we can verify that we're at least on track. I am not a handwriting analyst. I'm not an expert, but you tell me. Okay, that's the signature on the verdict form. Those are his signatures. This is the signature on a notice of commencement. Looks pretty darn close to me. And again, here's another one. Certainly looks very similar. Now, I want to also say that we looked at all of the Charles Moores that we could find on the voter registrations and in the clerk of court documents, property deeds, traffic tickets, etc., marriage licenses, and none of those signatures came even close to looking like this Charles Moore on the verdict form. Now, did we just automatically assume that that was the right one? That this Charles Moore is this Charles Moore? No, of course not. We did not just stop there. We didn't take one document and say, well, he's the guy. We actually looked at all of the clerk of court records in Miami-Dade in and around the time of Mr. Pierre's trial in 2006. We also looked at voter registrations on the Florida voter registrations website. And we looked at signatures on property deeds, traffic tickets. What else? Liens, marriage licenses. We looked at all the different Charles Moores to see, did any other Charles Moore have a signature that came close? And the answer would be no. Now, again, we didn't stop there. We also looked to verify the things that this Charles Moore said during the voir dire. We looked to compare, did those things match this Charles Moore's background and what we were finding in his case? And ultimately, yes, we were able to compare, and in our professional opinion, the Charles Moore that we talked about in our report was the Charles Moore who served on Mr. Pierre's jury. But back to this novel written by Judge Hirsch. On page 5, he said, but the search into the intimate details of those related, however distantly, to the Charles Moore who may or may not have been Mr. Pierre's jury foreperson was far from at an end at that point. Covert Ops was at pains to learn that Charles Moore's mother was killed in a tragic auto accident when Moore was 12 years old. And yes, that made me very sad. They also learned that Sharon Ann McDaniels, who may or may not have been the sister of that Charles Moore, brought a civil lawsuit as a consequence of the accident. Covert Ops made sure to learn that Sharon Ann McDaniels had a criminal record involving arrest for batteries and possession of open containers. Then Covert Ops went about ferreting into the lives of Charles Moore's children. It appears that there is a Charles Moore who had 2 children, a son and a daughter. As a result of a painstaking search Covert Ops learned that a Charles Moore had a son who had, for at least a time, a license as a security officer. We did not find that he had a license as a security officer. What we found was that a license for renewal had been denied. Whether or not he ever served as a security officer is not something that we were able to determine. Back to this. He, Charles Moore, foreperson's son, had at some point been charged with marijuana possession in violation of a county ordinance, but the charge was dismissed, and with petty theft, which was also dismissed. Now, see, when you got them dead to rights, and I read the police report, and it's just simply dismissed, makes me wonder, did somebody make a phone call? Next, Covert Ops went rooting around in the lives of Charles Moore's wife's family. The foregoing is but a brief summary of the inquest that Covert Ops conducted into the personal life of a man who may or may not have been the jury foreperson in the trial of Mr. Pierre, and of that man's wife and children, siblings, parents, and in-laws. In conducting this inquest, Covert Ops did no more than it promised on its website. Indeed, it did less. Okay, now here I started to get mad again. More assumptions. Recall that the website ballyhoos that Covert Ops researches the jurors, their family and friends, and everyone associated with the case. Accusers, victims, their friends and family, law enforcement, witnesses, all courtroom personnel, etc. Yes, we do. Judge Hirsch said here, at least the victims and their friends and family, law enforcement, witnesses, and all courtroom personnel were spared the minute, I'm getting irritated. We're spared the minute and invasive invigilation. I'm gonna have to look that up. I didn't look that word up. Anyway. Invigilation that Covert Ops lavished on a man named Charles Moore and on his family members, living and dead. Now, see, again, you have assumed that we did not look into all these people. Simply why? Because they weren't in the report that I wrote? Maybe, just maybe. We found no connection between the jurors and the accusers, victims, their friends and family, law enforcement, witnesses, and all courtroom personnel. And the answer to that would be, that's true. That's why it's not in the report. If we did, it would have been in the report. But we absolutely did exactly what we promised and then some. Back to this. Armed with the fruits of his colleagues' labors, Mr. Savy brings the present motion alleging that foreperson Charles Moore concealed material information that demonstrated actual bias. On that basis, he asserts a deprivation of Mr. Pierre's right to an impartial jury guaranteed, and prays that Pierre's judgment and sentence be vacated and a new trial ordered. He put down here in the footnotes, the entire investigation conducted by Covert Ops hinges on the guess that the signature on a document associated with real estate transactions is sufficiently identical to the signature on the verdict in this case in 2006 to justify the conclusion that the author of one signature must be the author of the other. This guess, we don't guess. This guess was made without, so far as the motion reveals, the aid of a handwriting analyst. Rather, I make this assumption because, there's that word again. I make this assumption because even if all the facts alleged in the motion are true, Mr. Pierre is entitled to no relief. But you're not biased. And what did Mr. Moore, the real Mr. Moore, the jury foreperson, do to deprive Mr. Pierre of that fair and impartial jury guaranteed by 2 constitutions? Well, I'm glad you got that right. The motion at bar alleges that he, quote, falsely claimed that his son had been in law enforcement. But the motion itself alleges that for at least some period of time, Mr. Moore's son was a licensed security officer. Had Mr. Moore omitted to mention his son's employment as a security guard, well, because it really isn't law enforcement, no doubt the Savvy Covert Ops team would scream that this omission deprived Olson Pierre of a fair and impartial jury. See, now we're getting into slander as far as I'm concerned. But again, I'm not an attorney, and I'm certainly not a civil attorney. Be interesting to know what one says about that, though, wouldn't it? Additionally, he said, the motion announces foreperson Moore failed to disclose his sister's extensive criminal history and the death of his mother as a result of his father wrecking his vehicle while driving intoxicated. Foreperson Moore further failed to divulge that his sister sued their father due to the death of their mother. Apparently, Mr. Moore acknowledged that his brother, but not his sister, had been arrested. He was questioned in voir dire as to that by the prosecution counsel, and his answers were deemed satisfactory to one and all. Yes, but he didn't tell the whole truth. If he'd told the whole truth, would his answers have been satisfactory? I don't think so. In fact, I'm sure. Excuse me. I'm not sure. I'm confident. Few more pages, the few more excerpts. The motion does not identify the question or questions asked by the court or counsel in voir dire that, in the opinion of the author of the motion, should have elicited this information from Mr. Moore. The motion alleges that Charles Moore was asked in jury voir dire, quote, if he had any close friends or family members who had ever been arrested or convicted of a crime. Foreperson Moore deliberately chose to conceal this information and mislead the trial court, the defense, and the state by falsely disclosing only his brother's criminal past. Yes, that is what the motion written by Mr. Savvy alleges, because that's true. The motion repeats the claim that Mr. Moore lied in identifying his son as having been in law enforcement. As to that point, trial counsel for Mr. Pierre conducted voir dire of Mr. Moore and was clearly satisfied. Yes, because at the time of voir dire, you thought he was telling the truth. He wasn't. Well, I should say, the truth, the whole truth, and nothing but the truth is what is expected of him. That is not what they got. Then, last page here, Judge Hirsch said the motion is untimely and subject to denial. The motion is untimely by a decade and a half and subject to denial on that basis alone. The motion at bar asked this court to vacate the judgment and sentence imposed. If the court were to do so, it would be impossible to set this matter for retrial at this late date. Court records and evidence have been abandoned long ago. Witnesses have died, forgotten, moved away. And having received what to all appearances was a fair trial, in his opinion, at a time when the state was able to prosecute this case to conviction and obtain an incarcerative sentence, Mr. Pierre now wants his judgment vacated at a time when the state cannot prosecute this case at all. It's not about what we want, it's what is fair, what is just. In the criminal justice system that Mr. Pierre envisions and that Covert Ops promises, no judgment, no outcome in the criminal courts will ever be truly final. The people of the state of Florida deserve a much better criminal justice system than that. Finality. But what if you're innocent? What if you're framed? What if the state puts people on the stand who they know are lying so that they can get a conviction out of you while these guys took a deal? Is it because the state of Florida and all the other states in our union put people on the stand that they know are lying? They pay them, they coach them, they depend on them to lie on that stand so that they can get that guy convicted, knowing that guy's not the guy, not the one. They don't care. It's about a conviction. Remember? What's the end goal here? Oh, that's right. Become a judge. Can't become a judge if you don't win. What if you're innocent? Go to prison and die? That's what Judge Hirsch wants. Finality. If you've been wrongfully convicted or you know someone who has and you need our help, you will find our contact information in the description below. I hope and pray that judges will take the time to consider that maybe, just maybe, the person sitting at that defense table is innocent. Thank you for watching. Like and subscribe. I would be honored. I look forward to next time. Remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.